My name's Charlie Pieterse. With me here today is my partner, Wyatt Jansen. Wyatt and I are partners in the Cummings and Lockwood Litigation Group, and we focus our practice on probate and fiduciary litigation. So we're very pleased to be with you today and to talk a little bit about some tips you can use as you navigate some difficult issues with your clients. So today's presentation is entitled Trust and Estates Disputes, How to Spot Red Flags and Minimize Risk. Now, disputes concerning the transfer of wealth and power are endemic to the human condition, I think, right? We all are aware of that. And we all have to deal with them in our lives, and I'm sure you all deal with them in your practices. We find in our practice here that these type of disputes are on the rise. And there are a number of factors, I think, contributing to that. And I think these are factors that each of you are aware of, but maybe the confluence in this context isn't something you always think about. So the first factor is we're in the midst of the greatest generational wealth transfer in history. As the baby boomers age out, transfer their wealth, we're talking about some estimates of over $100 trillion being passed down to succeeding generations. So there's a tremendous amount of wealth there. The second issue is people are living longer, especially in this area. The life expectancy continues to rise. And, back in 1918, I think the average life expectancy was in the late 50s, early 60s, and today it's in the late 70s. And the third issue is that the ability of succeeding generations to build wealth, it doesn't match that of the baby boomers, especially the millennials and the Gen Z generations. So what does that mean? You have a lot of wealth out there. You have people living longer before it's being passed on at death. And you have the beneficiary class who is having an increasingly difficult time creating the ability to maintain the standard of living to which they've been accustomed. So all these things percolate together to create disputes. In my experience, disputes are on the rise, particularly in the area of pre-death disputes. I think all of you here are what I would call the canaries in the coal mine, right? So you're the ones who are going to get the first sense that there may be a dispute on the horizon. And so we're just going to go through some red flags and some tips on how to identify and navigate those pre-dispute issues.
Sure. And nice to see everybody today. So the first red flag we're going to talk about is unusual information requests. So this could be directed to you either if you're serving as a financial advisor, but also I know probably some folks in the room serve as fiduciaries of trusts. And so you're typically going to get information requests in that role as well. So I think, regardless of whether you're in a fiduciary capacity or an advisor, the first thing you want to do when you receive an unusual information request is to start with where you are in the structure. Put another way, zoom out and think about, what hat you're wearing with respect to, the information requests that you've received. Are you serving as a fiduciary? Are you serving as an advisor? Who is your client as an advisor? Where you sort of sit in the grand scheme of things, is the account you're managing or the trust you're managing, part of a larger structure, either a larger trust structure or a business organization structure. And you want to also think about sort of where the person who's making the request for information sits within that structure. And so it just kind of like, as sort of try to think about like the Waystar Royco org chart, right? You may be sort of a pale blue dot floating in a vast universe of entities and trusts, and you may only see a tiny sliver of it. So I think like regardless of where you go from here, you always want to stop, pause, take a breath, and think about where am I? So, more specifically for advisors, obviously review the account ownership information, confirm who has the legal authority to authorize disclosure. So if it is a trust account, you don't have the authority to authorize disclosure. That's the trustee or another fiduciary who has the authority to authorize disclosure. You want to obviously confirm if you're part of an organization, what the internal restrictions are and due diligence you need to do before you share information. These are questions for your general counsel or your compliance department. Consider, who should actually be responding to the request, because it may not be you. Somebody may make a request of you because you're a longtime trusted family advisor and they know that you're managing the family accounts. But if the account is owned by a trust or even an individual, the proper person to authorize, right, disclosure of that information is the person who owns the account. And so if you're sitting in an advisor role, right, the probably the best thing you can do is to defer to somebody else to make the decision about what information you're authorized to share, and then make sure that you are dotting the I's and crossing the T's internally, that you have, the appropriate authorization to share that information. You may also want to consider how you respond. So somebody may pick up the phone and call you with a request for information, but you may want to respond in writing. I think from a litigation perspective, we're always thinking about creating a written record on, information requests like this. And so it may be that you want to send an email that says, you requested X, Y, and Z information from me. The information you've requested belongs to this trust, this business entity, this individual, and you should direct your request to them. And I'm happy to work with them, if they authorize the request, so that it's very clear that you've communicated that information to the person and it is no longer your responsibility. So for fiduciaries, and I think there may be some folks who serve as fiduciaries in the room, it's a little more complicated because you typically will be, or you and your co-fiduciaries will be, the person who has actual authority to determine whether to provide the information that's requested. So step one would be you want to identify the true owner of the information. And this gets complicated, at least in our experience, where there's a business interest that's held in a trust or an estate. Just because the trust owns a business interest or a piece of that business interest does not mean that is quote unquote trust information. That information may belong to the business entity itself. There may be different decision makers who control the release of that information. If it's a corporate entity, it could be a board of directors. If it's an LLC, it would be a manager. There may be restrictions on information rights under either the operating agreement, the bylaws, whatever the case may be for that particular type of corporate entity. And so as a trustee, you may not be the right person to say, yes, I agree to give you that information. And it may not actually be trust information. This is kind of a nuanced issue, right? Both state law varies from state to state on information rights. The law is very different between Connecticut and New York on information rights when it comes to business entities held in trust. And it also will depend on factors like what percentage ownership interest the trust or the estate has in that entity, whether the trustees or the executor or the fiduciaries have actual control. So do they control the board of the entity? Are they the manager of the entity? The greater the sort of Venn diagram of, trust and business entity overlap, the greater likelihood that you're going to be obligated to provide that information. It's complicated, but you want to make sure that you don't just assume that it is trust information if it's being requested from you in a trustee capacity or another fiduciary capacity. Obviously want to also determine the requester's legal interest in the information. So are they a beneficiary? Do they have a direct ownership interest themselves in like a business entity? So again, kind of zooming out, thinking not only about what hat you're wearing, but also what hat the person requesting the information is wearing. Like I said, there may be information restrictions under the governing instrument, whether that's a trust or it's an operating agreement or corporate bylaws. There's also going to be an overlay of state laws, I sort of mentioned to that. So if this is a Delaware LLC, there's a huge body of case law in Delaware on information rights of LLC interest holders that is going to be relevant to assessing the information you provide. And like I also sort of hinted at, you want to confirm who the correct decision maker in this instance is. That's kind of the overview. I would say probably in our experience, information requests are the most common leading indicator that a dispute is coming. It's important to handle it really sensitively because, if you say no, that is likely to engender a dispute. But if you say yes, the concern is always that something in the information you provide is going to trigger a dispute itself. And so I think our experience and our recommendation is to balance really sensitively what information you agree to provide and to be very cautious about simply stonewalling if the person has information rights, because you are then putting the person requesting information in the position of having to bring a legal proceeding in order to get that information. And if the stakes are high enough, they will likely do that.
I just want to emphasize that this is such a difficult issue, especially when requests are made to trustees concerning business interests that the trustees may hold a partial interest in. Wyatt and I prepared materials for the American College of Trust and Estate Counsel meeting last year, and if anybody would like a copy of those materials, you just let us know and we'll forward those to you. But it's a really, really difficult issue. And when you look at the cases, the judges seem to like break it out into like the Goldilocks analogy, whereas, the fiduciary either provides too little information or too much information or just the right amount of information. But how you get there, as Wyatt said, varies by state to state and can be a really difficult road to walk. So definitely proceed with caution there. All right, moving on to our next topic. When you're dealing with a client who shows signs of diminished capacity. So we're not talking about incapacity here, but the road to incapacity begins with diminishing capacity. A lot of your clients start out like Logan Roy, they're, command of all their faculties. They know what they want. They direct you clearly on how they want to do it. He or she has a plan, and as time sets in and passes and life changes, it gets more difficult to help them navigate that. So let's talk about that for a minute. So first, what are we talking about when we're talking about, diminished capacity? Once you hit the age, the scientists say, of about 50, you begin to experience some cognitive decline. And that's normal, right? Which, all of us can take comfort in. It doesn't mean we have diminished capacity. It's something I'm always telling Wyatt. Look, my inability to remember that is just something that's, normal at this age. So we're not talking about, somebody who's taking a moment to find a word. We're talking about something a little bit more serious. And what are we talking about then? And again, this is really where you all are, the canaries in the coal mine, because you're going to see this firsthand. So we're talking about when your clients, are having memory lapses or they're forgetful about how to manage their accounts. And if they're paying their own bills, they're missing bills. They're paying bills twice. They're incurring late fees. We see this, all the time. They show an increased anxiety about financial issues. Either they somehow, against all the objective evidence, feel that they're poor, or, they don't think that they can afford to pay everything they need to pay for. They just have unwarranted anxiety about finances. Or they become kind of smitten with get-rich-quick, schemes or something like that. They struggle with basic financial and mathematical concepts that they never did before, right? These are all signs that we've got some diminished capacity going on here. What do we do there? The first thing you do when you start seeing these warning signs is, to the extent you can, determine what legal documents are in place to help you navigate a client who's losing the ability to capably manage their affairs. The key here is typically a durable power of attorney, right? But you want to look in your records, see what the advanced planning the client has undertaken and who they have given authority to. Then you want to think about, have those documents become effective? You've got springing powers of attorney. You'll have situations where your client is a trustee, and then the trust documents can become disqualified by lack of capacity if two doctors have certified that they're meet whatever the standard that's in the trust. So you want to take a look at those documents and familiarize yourself with what things happen that will trigger someone else to act on their behalf. Here's my favorite: apply skepticism to requests. Because I think about this lack of capacity is there's a lengthy continuum, right? Where you start, and then when you're characterized as incapable, which means you've lacked the capacity to manage your own affairs, and you can have a court adjudicate you in that way, and we'll talk about that in a minute. But there's this continuum, it moves along the line. And that's when people are particularly vulnerable, as Wyatt will talk about when we get into the undue influence section. But when people come to you with questions or requests and you're beginning to see some signs that trouble you, make sure you ask them open-ended questions, right? Apply some skepticism, ask them what they want to do and why, and make sure that these questions require the person to formulate an answer. Because what I have found, and you probably have seen this, is that people, as they begin to decline, they're really good at covering it up, right? They're really good at deflecting and, changing the subject. But if you ask them a specific question as to why they want to do something, that then kind of can expose. And if they say, I don't remember, or I'm not sure, well, there you go. You just wait. If capacity is unclear in your mind, you have some tools available to you. And Wyatt, again, we'll talk about, there's a statute that's, it gives you some safe harbor protection. You may also want to engage in discussions with family members. This is an issue that lawyers struggle with too, and we have very specific ethical rules that govern that situation. But in my experience, most lawyers, are uncomfortable navigating that as well. But you can talk to family members. Here's a key one. Do not take direction from a family member without clear understanding of authority. Now, sometimes in the family order, one child naturally assumes, right, that they're speaking on behalf of their parent. I'm sure you've all seen that. But unless they hold a power of attorney, unless they hold some instrument, giving them the legal authority to act on behalf of their principal, you can't take direction from them. That's not to say you can't listen to them, but you can't take direction from them. This next issue is really a difficult one. Consider whether a court determination of capacity is appropriate. And as we say here, it can be very clear when you get a court order saying somebody needs a conservator that clarifies the issue of capacity, but getting to that point is really, really, really problematic. It involves, in Connecticut, one of two ways. You can have a involuntary conservatorship, which typically a family member will bring, and that's a adversary proceeding. But we also have a tool in Connecticut that most states don't have, and that's what we call a voluntary conservatorship. And we successfully use that tool a lot in situations where the patriarch or the matriarch is struggling, and some of the children or the next generation, are looking to find a way to deal with it. And without having to bring a conservatorship proceeding, we can get an agreement where we go into court and the person simply says to the probate court judge, I really want John Doe or Jane Doe to handle my affairs. And the person will be imbued with that authority, and the court will not make a finding of incapacity. And that's helpful sometimes for people's self-worth. As advisors and fiduciaries, when you're dealing with this situation of diminishing capacity, you got to think about what the person's state means as far as what kind of distributions might be requested coming down the line. Are they going to be needing some sort of specialized care sooner than you anticipated? Are they going to need to be outplaced in a memory care unit in a couple of years or a year? You need to start planning for that.
This is a related subject. When you suspect undue influence or elder abuse, and I say it's related because obviously as folks start to lose capacity, they become more vulnerable to these types of exploitation. So just to define some terms really quickly, so what is undue influence? This is essentially like a soft form of coercion where somebody uses a position of trust or control or reliance to extract benefits from a victim. And it's really important to kind of be on the lookout for this because if an act that somebody takes is deemed to have been the product of undue influence, it's voidable by the law. So whether that's changes to an estate plan or even requests for withdrawals or distributions, those can all later be legally challenged by somebody by saying that they were the product of undue influence. So you want to make sure, as the people who are sort of on the front line, that you're not enabling that and that you're on the lookout for this. Elder abuse it's not just physical abuse, although obviously would include that. It includes neglect, financial exploitation, and also depriving somebody of caregiver services. It's a broader spectrum of activities that could constitute elder abuse under Connecticut law. So signs to look out for, obviously, like I mentioned, cognitive decline. It just creates a vulnerability to exploitation. But you also want to look out for like a client who all of a sudden is being accompanied to meetings or on calls with somebody who didn't used to participate in those meetings or calls. You should be thinking about, why is a client making large withdrawals all of a sudden, or changing their spending patterns or their distribution requests. Another big one is abrupt changes to longtime advisors. So we see this with estate planning lawyers a lot. Somebody has worked with the same client for 20 years. A potential undue influencer or elder abuser comes into the picture, and because they want to change the estate plan, all of a sudden a new estate planning lawyer is retained who doesn't have the family background, doesn't have the history, and maybe doesn't have the same scruples as, the longtime family advisor. Some categories of folks to just be wary of would include any cohabitating non-spouse family members. So this could be like adult children who still live at home or who never left home, more distant relatives who, for whatever reason, are cohabitating with your client, which is not unusual with very wealthy folks. Caregivers is another category of people who you want to be on the lookout for. Relatives who are unemployed or just unoccupied in general, have time on their hands to unduly influence folks and maybe an incentive. And just kind of anyone who seems overly involved in financial decisions and you're not sure why. Strategies to protect clients, a lot of overlap with what we talked about with diminished capacity. It's really helpful to make sure that as best you can, you're speaking directly to your client alone and without the presence of folks who shouldn't be participating in those conversations. Asking open-ended questions, asking why. If somebody makes an unusual request, like a large distribution request or wants to make a big investment and you don't understand why, a great strategy is just to kind of defer that, give them time, a few days to think it over, follow up with them, and see if this is something they still actually want to do, if they even remember that this is something they asked you to do, and if they can articulate the reason for that. As Charlie mentioned, there is a safe harbor for elder abuse. So for folks who are working at financial institutions, you are authorized under Connecticut law to place a hold on an account when you suspect elder abuse. The safe harbor means that you're not going to be liable for having placed the hold. You're not required to place the hold if you do suspect elder abuse. You're just allowed to. And you're not liable if you elect not to place the hold. But it's an important tool to have. And it's nice that we've clarified that, folks are not going to be liable for taking that step. And if you suspect elder abuse, you can also report it to the state. There's a Elderly Protective Services, which will then investigate.
Yeah, and when I mentioned before about those three factors, coming together to increase the litigation that we're seeing, now we're really focusing here on people who are living longer. And so the opportunity to unduly influence someone is lengthened, right? There's a greater opportunity for that. But as I often tell clients, the law doesn't protect people from making bad decisions. Your client is, under the law is free to make bad decisions. It's when somebody is, subverting their decision-making authority and implementing their own goals and objectives that we're talking about undue influence. It's really easy to say in retrospect that was undue influence. It's really hard to say in real time as it slowly unfolds what it is. So proceed cautiously is the best advice we can give you there. And you really are on the leading edge there. And all these issues these situations that Wyatt was pointing out about people to be wary of, every one of those classes of people, we've been involved in litigation. It never ceases to amaze me what people think they can get away with. One of the reasons I love this practice of law is the stories are great, but,
If they're not happening to you.
Right. But of course, given our professional code of ethics, I can't really share all those stories, but, I just have, it never ceases to amaze me what people do. Moving to our next topic, changes in family composition or dynamics. If you were a fan of the Succession show, as I was, I'm sure we all rejoiced in Connor and Willa's marriage, which arose under really unique and strange circumstances, right? But these type of marriages, and these situations are not uncommon. I recall getting a phone call once in my office, and this was not a client, so I'm not revealing any confidences here. And the person who called me said, I need help. true love is being subverted by my husband's children. And, and if anybody saw the movie The Princess Bride, they know that true love is a really important concept. So I immediately said, well, what are you talking about? And it turned out the true love was between like an octogenarian and the caregiver in the nursing home he was in, who after his wife of 60 some years passed, the caregiver found true love with him, in a 2-week period of time and married him. And the kids, of course, got very upset and sought to, undo the marriage, which they were able to do successfully, I'm happy to report. But she was seeking someone to represent her. And of course, I said as much as I was a fan of true love, I couldn't involve myself in that. So marriages, divorces, remarriages, having children reaching adulthood, and family rifts all change the family dynamic and introduce the risk of disputes. No truer words were ever spoken. And the really difficult issue is often between a second or third marriage, right? And children from the prior marriage or marriages. There's a natural conflict of interest there when it comes to the division of assets, and there just never seems to be enough assets in people's mind to go around, and we see that all the time. So if your longtime client comes in with his new spouse, his new girlfriend, her new boyfriend, her new spouse, be wary, right? Proceed cautiously. And, always remember who your client is in this situation, right? It's not the new spouse, it's not the new friend, it's your original client. And pay close attention to who is scheduling the meeting, who is talking at the meeting, who is outlining the distribution pattern that they're looking to change. And you'll often see a situation where someone comes in and says, Mary here, she wants to leave her estate in a different way now. No longer wants to give it to her kids, she wants it to give it to me. And my kids, isn't that right, Mary? Mary will nod her head, right? And you've got to be very wary of that situation. Make sure in these situations you connect with the total advisor team, whether you're with a family office, you're with an investment group, an accounting firm. The network of advisors is often deep. It involves different professionals, and there's nothing wrong with connecting with those individuals and talking to them about what changes they may be seeing or what conduct they may be perceiving that concerns them. But as Wyatt said, from my perspective, there's no redder flag than the change in advisor, getting rid of a long-term advisor and going to a new advisor. And these situations here are rife with those type of things. Wyatt, I'll pass the baton back to you.
Sure, and we're running a little over, so I'm going to take this one really quickly. Lack of alignment among family members, really common cause of dispute. Could be lack of alignment on investment philosophies, lack of alignment on staying involved in a family business versus just investing in the market, lack of alignment about distribution levels, reinvestment. These arise because often in obviously like a multi-generational family or a family where there's, let's say a bunch of siblings, some have kids, they want to preserve wealth for the future, some don't have kids, they want to spend the money now. And I think there's really broadly two ways to approach this. One is decoupling if you don't think that these differences are going to be reconcilable, and there's different ways of decoupling. You could just buy somebody out of the whole family structure, or you can create, through trust divisions or decantings, separate investment vehicles for different people who have different philosophies, beliefs, or desires for distributions. Or there's sort of the realignment strategy, which is when obviously you think these differences can be bridged. This is like what we see like family peace agreements, creating dispute resolution mechanisms, creating family sort of like mission statements with the idea of sort of like trying to coalesce around what folks agree on, trying to figure out a way to resolve disputes that doesn't involve litigation. And I think that's like a great note to end this on, because although like our job is litigation, I think where we can and where we provide the most value to people, because litigation is destructive of value ultimately for families, is to try to avoid litigation or resolve it. And we have more tools than ever now to do that with decanting and things like that. So that's kind of our goal when we can achieve it.
Thank you.